All right, Robert Gruler here. Today we're talking about disorderly conduct in Arizona and what that means, specifically how the statute works, where some of the major problems are with how this is prosecuted, what some of the defenses are, and how you can be successful if you've been charged with disorderly conduct, because it's not a very clear statute. It's something that has a lot of ambiguity in there, something that, in our opinion, is significantly overcharged. It's more or less kind of a catch-all violation that the police will show up and they'll just write to everybody because it's very easy to write and the government likes to hand them out, and a lot of people don't like to fight them, but there's a lot of ways that you can do that. So let's jump into it. Let's take a look at the statute first of all, and as always we'll go to the whiteboard. So I have pre-written this out, but this is the statute for disorderly conduct. Now, it's a big statute. There's 6 different components to the actual activity that needs to happen in order for disorderly conduct to be charged, but we're really going to only focus on the top 3. The bottom 3 really aren't charged that often, but we'll touch on them briefly. So in any criminal case, when you're charged with a crime, there needs to be 2 main elements in order for the government to bring a case. You need to have an actual act. In law school, they call this the actus reus. This is an activity. This is some sort of action that actually occurred. Then you also have to have a mental state, or you have to knowingly or have something in your mind, something that actually occurred in order to, mentally occurred in your mind in order for it to be a crime. So you have an act and a mental state. You have an actus reus and a mens rea. These are the legal terms of art. But so we're going to run through that and how they apply in disorderly conduct. So when we're talking about the act, something that physically happened, something that in the real world happened outside of your mind, we see that there's 3 different ways that disorderly conduct is most often charged. Number 1, you can engage in fighting or violent or what's called seriously disruptive behavior. That's probably the most common way that disorderly conduct is charged. Now, what does that mean? It's open to a lot of interpretation. What is seriously disruptive behavior? It's up to be interpreted by the judge ultimately, but you can see where there's some ambiguity there. The other way that we see it is under subsection 2, which is when there is unreasonable noise. This is the act that occurs. There is some sort of unreasonable noise. Again, what does that mean? It's open to interpretation. The third way that you see it, it's less common, but is when there's abusive or offensive language that's happening that would tend to provoke somebody to respond immediately. So this is if you're getting into kind of a verbal altercation, you're swearing, you're saying things about their mother, something happening where that would provoke that person to respond, that can be considered an act that would be categorized under disorderly conduct. The other ways that you see them are under subsections 4, 5, and 6. Under 4 is really when you're doing something that would prevent some sort of business from happening, whether it's a city council meeting or something where you're getting involved, you're causing commotion, and you're preventing business from happening, you're preventing the purpose of that meeting from going forward. Under number 5 is where you're refusing a lawful order. Essentially, this comes down to if the police are appearing and they're asking you to disperse, if there is a public safety or public concern and they ask you to leave and you don't do that, that could be under category 5. And number 6 is when you're, this can be charged as a felony, but this is when there's reckless use of a firearm or a dangerous instrument. So if you're mishandling something, if you're waving a gun around, or if you're doing something that's dangerous with a firearm or a dangerous instrument, that could be an act under disorderly conduct. And so you can see any one of these are actual activities. This is something that you are physically doing that would fall within the purview of this statute here. As I mentioned earlier, there also needs to be a mental state. So you need to knowingly or you need to do something in your mind to further one of these acts in order to meet those 2 elements, the act and the mental state. And so under the statute, and then if you look at the statute, this is actually on top, so I'm going over it in reverse order. But the mental state is you have to have the intent. You have to intend to do one of these things in a way that's going to disturb the peace and the quiet of the neighborhood, a family, or a person. So you have to set out intentionally trying to do one of these things. And so most people don't do that, but sometimes they do, and that's how they connect those 2 dots. They say a person intended to do it, and then they did it. Or you have to have the knowledge that what you were doing was disturbing the peace of the neighborhood, a family, or a person. So you either have to intentionally seek out to disturb something, somebody, a family, or you have to do something knowing that that is going to be the cause of that. And so that's how the statute works. You have to have the mental ability, the mental knowledge, the mental state to be doing one of these things in a way that's going to disturb the peace. And so you can see that this is very ambiguous. There's a lot of room for interpretation under this statute. What is actually disturbing the peace and the quiet? You know, it depends. If you're in the dorms, that may be something different. If you're in a college town, that may be something different than if you are in a center where there's a lot of retirement homes. You know, there's a lot of difference. There's a lot of room for interpretation here. So this is a very broad statute. Now, the police like to charge it because of that, because it is so broad. They can show up and they can say, person A says that you had engaged in some activity that bothered them, that disturbed their peace and quiet. Therefore, they're going to charge you with disorderly conduct. We typically see this when there's not a lot of evidence for other charges. They just use this as a catch-all and they just say, you're being charged with disorderly conduct. If you don't like that, you can take it to court and you can fight it. And so one of the main ways that you see defenses be successful in a disorderly conduct case come when you are talking about what evidence can actually come into court. So let's just take a quick look at an example that we see often. So let's say, for example, there is a couple and they're in their house and you've got couple A and you've got couple B and they get into an argument, something that happens all the time. Next door in the apartment across the hall or right next to them, you've got a witness here who hears some sort of commotion, they hear some sort of argument, and they call the police. So the police come. So you got person A, person B, you've got the witness, then you've got Officer C who comes and they respond to the actual altercation. They're doing an investigation. They want to say what's going on. They make contact with the witness. The witness says, I heard something. It woke me up. I heard fighting. I heard something happen there. Okay. Officer C goes to the couple and goes to the couple A and B. They talk to them. They need these two people to connect these dots. So the witness will have heard something, but what the witness heard, does it rise to these levels? Does it rise to fighting, or does it rise to a normal argument? There's a question there. Couples argue. Is that seriously disruptive behavior? That's open to a lot of interpretation. Even if it does rise to that level, the cop, the officer, the police officer who responds to it, they would need this witness to come into court and testify about that, about what they heard rose to that level. And in most cases, this person, this witness, they want to go on with their lives. They called the police to make sure that nobody was getting injured or that this thing was passing, or they were scared and they didn't know what else to do. But in most cases, this situation has resolved itself. The police didn't need to get involved at all. And so this case 3-4 months down the road from now, when the criminal case is proceeding, is this witness going to want to come into court and actually testify? And if they did come in and testify about what they heard, is it going to rise to these levels? Can this individual, the only person who actually witnessed anything, remember the cop came after the fact. They were called after the fact. So in most cases, they did not see or on a first-hand basis witness any of this happening. So they can't testify about actually witnessing this firsthand. They need to rely on this person. So is this person going to come into court? Can they testify about the intent or the knowledge of one of these two parties? Very unlikely. Can they testify that they intended to make unreasonable noise, or they knew that they were making unreasonable noise, or that they were engaging in seriously disruptive behavior with the intent or the knowledge of doing so? It's very unlikely. So that's where you can see there are evidentiary problems. Now, the police officer, he cannot come into court, or she cannot come into court and say, Your Honor, Judge, witness told me that these things happened. That's what's called hearsay. So the officer cannot take an out-of-court statement that was made by the witness, take it into court, and then use it against A and B. That's excluded under the rules of evidence. That cannot come into play. What the officer needs and what the government needs in order to secure a conviction here is to bring the witness in and have that witness come into court and testify. That's firsthand account. That person's testimony can come in, but the officer saying that the witness said X, Y, and Z cannot. In many cases, there is no witness. None of this is even existing. You only have an altercation or something happen between A and B, and now the police arrive, and A and B don't want anything to do with this. This was a temporary argument, something that's totally normal, totally natural, happens between couples every single day. Police don't need to get involved in it, but some jurisdictions just like to do that. They've got apparently nothing better to do. So they come and they start asking questions, somebody gets arrested, they charge them with disorderly conduct, and now there are no witnesses because one of the two people do not want to testify against the other one. And so that makes the government's job difficult. It makes it hard for them to be able to secure a conviction. That doesn't stop them from charging this. This is something that we see all the time. It happens in hotspots kind of around bars and other areas where there's a lot of commotion, a lot of activity. It doesn't change the dynamic that you saw there. There still needs to be somebody to come into court and actually testify and actually bring their case in so that they can meet those elements. It's not as easy as it sounds. So if you've been charged with disorderly conduct and you're not seeing any headway on your case, if you do want to come speak to our team, we'll review your facts specifically, see if it's a good fit to work with us so that we can make sure that these defenses are employed 100% to your advantage, make sure that there are no loopholes and that you're not getting railroaded or taken advantage of throughout this entire process. So we offer free case evaluations. Give us a call, come speak with me or a member of my team. Thanks for watching.